I mean, there's no bifurcation, but in England, there's bifurcation, all that. So hitherto, prior to 1888, and 1888 on 30th of January, 1888 was the day a first Nigerian was enrolled as a lawyer, and that is Christopher Alexander Sapara Williams, the father of Rotimi Williams. And before then, lawyers, dances were given and people engaged in practice who were not lawyers. And then in the same vein, law was initially practiced by only the rich, the elite, so that they can dispense with the fees. And so before now, only the affluent possess the prerogative or the monopoly of legal practice. But these days, it's no longer the same. The law practice now accommodates tons of qualified lawyers who can live from it. Legal practice has been described even by the Supreme Court as a very serious business that is to be undertaken by serious-minded professionals. Then we can now see that legal practice enjoys an expansive hemisphere. That is, you have so many areas that can be harvested: litigation, civil or criminal, corporate practice, legal advisory services to individuals, corporations, and government, negotiation of economic transactions, drafting of agreements, just etc. However, we must note, and we know that a legal practitioner is not armed with a carte blanche license to practice law. He is bound to practice within the perimeter, letters and spirit of the Legal Practitioners Act and rules of professional conduct. So a lawyer, while ensuring the enthronement of rule of law, the soul of democracy, and the enforcement of justice, must observe to the letter the ethos of the noble profession. He must be an epitome of a repository of good character, truthfulness, candor, trusty, and honesty. So there's no gainsaying the fact that lawyers who have been accused of being the holders of the key of knowledge, that is what the Bible says, acquire humongous wealth from legal practice globally. Legal practice is a gold mine for wealth. In Nigeria, there are an army of successful lawyers in legal practice within the socio-economic firmament. Nevertheless, there are a flood of socio-economic uncertainties that bedevil legal practice in Nigeria, thereby enabling on its profitability. A consideration of a few of these, both extrinsic and endogenous, is a heartbeat of this profession. And so one has to look at how the socio-economic uncertainty looks like. And this way we said, indisputably, the economy is the basic foundation of every society, and law reflects the nature of economy. It admits of no argument based on empirical evidence that the global economic crisis, the minister just said that now, it ravages the entire universe. Nigeria is not an exception. Our economy is wobbling and engulfed in instability. It is a bleeding economy. It is exacerbated by uncontrollable galloping inflation, which bets astronomical rise in cost of living, low purchasing power, and quality of life, geometric increase in prices of basic goods and services. The value of our national currency in Nigeria has nosedived to an abysmal level. This has inflicted financial hemorrhage and uncertainty on the citizenry. Corruption is an amorphous and polymorph phenomenon, which is also a unified definition. And corruption owns variegated species, political, social, economic, bureaucratic, just a lot of them. It's a transnational cankerworm that permeates every facet of the Nigerian society, thereby making many Nigerians corruption-friendly. It has, with the aid of its leprous tentacles, wreaked immeasurable havoc on the economic, social, and the moral fabric of every society in the world. Many countries, including Nigeria, are mired in the intractable web of insecurity. It manifests in diverse forms and dimensions: communal clashes, banditry, insurgency, kidnapping, human trafficking, etc. Its aftermath are incalculable. It is characterized by untold hardships. Insecurity destroys communities, displaces people, and transfigures them into internal displaced persons, stunts economic growth, inhibits local and foreign investment, creates famine, nurtures pauperism, etc. And we also know that social amenities, such as housing, health, education, roads, potable water, electricity, is grossly inadequate, epileptic, and dysfunctional in this country. And then now look at the weight of all this on the legal practice. How have these situations affected legal practice? And that's where the uncertainty comes from. And we have said that at the confluence of economic instability, absence of social amenities, insecurity, and pandemic corruption, in the polity is abject poverty. People are impoverished. And like Kuputa put it, next to slavery, poverty is the greatest assault on human dignity. And so poverty is a serious stimulus for poor living conditions of the people, which in turn impacts negatively on legal practice in Nigeria, especially as about 54% of Nigerian population lives under poverty line. And people who are also immersed in the nest of insecurity, suffer from of wherewithal, no resources to sustain livelihood, have for terror to hire the service of a lawyer for acquisition of property or prosecution of curtailed legal rights in the temple of justice. They sacrifice the pursuit of their access to justice on the deserved altar of livelihood. Besides, in some places, marooned in the murky ocean of insecurity, there are no courts of law to besiege for enforcement of infringement of legal rights. All this concern legal practice in the limbo and make it a Cinderella of legal profession. Because there are no courts, where will you go? The security has destroyed almost everything. And want of social amenities castrates the flourishing of legal practice. Legal practitioners involved in interstate legal practice, which many lawyers here I know are involved in, cannot travel by road because it is a complete nightmare. And in the face of their poverty-stricken clients, some of them though, they cannot afford to travel by air. A greater chunk of the revenue generated from the legal practice is poured into self-provision of social amenities to nourish life. And there's the absence of these social amenities, which are sine qua non for survival, is a serious mitigating factor against legal practice in this country. And then we have tried to outline some of the, some areas that has affected. And we go to poor remuneration. Lawyers, young lawyers now, like even the minister indicated, are poorly paid. There's no, and it is as a result of, the economic situation in the country. A senior lawyer may not be able to pay the lawyer he has engaged very well. I'll give you an example that paid me when I was in practice. That was around 1990. I was just in a chamber. I finished. We just in a chamber, and he was a senior advocate. He was paying us 400 naira. He would say 400 naira then was big money. But on top of the 400 naira, he wouldn't give me the money cash. The chambers wouldn't give me the money cash. They'll give me a check to go to bank, African Continental Bank that time. I said, and now that will deplete even the amount of money you are going to get out of this thing. And when eventually I discovered 400 naira couldn't pay my bill, of course I left him and I got another chamber. Just within one day, I was able to make almost more than that because I was given free hand to practice, And the man who employed me that time sold better because he was kind, and then unlike the other person. And so many lawyers are not well paid. We know that very, very well. There's no dispute about it, and it as a result of the poor economic situation in the country. It's not the same in other countries, in other climes, because those people, their situation is better, in foreign climes. But it is, let me just highlight what a legal commentator said about the effect of poor payment. He chastises this in these words. He says, inadequate remuneration of junior colleagues is a thorny issue which a lot of senior lawyers would avoid discussing at any gathering. Despite several years of academic study at the law school and at the university, many lawyers find them earning less than cleaners and drivers in many corporate establishments. Already, the harsh economic situation has caused disillusion among bright young men and women who had dreams of becoming senior advocates of Nigeria and has led them to more lucrative jobs which have nothing to do with the law they studied. We now have lawyers who work in the marketing departments of banks, sales departments of other banks. And so junior lawyers now desert legal practice and settle for odious jobs which are quite incompatible with a position as a legal practitioner, which is not the best thing, and it is the cause is this socio-economic insecurity. And by the same token, underpayment of lawyer. When you underpay a lawyer, he must find a way out to make ends meet. And because of that, he will indulge in a very sharp practice, the practice of undercutting the office. Whatever he sees, if you are supposed to charge maybe 100,000 for instance, he will just charge 10,000 naira and get out of it. And while doing so, that is also bad because there is the Legal Practitioner Remuneration Committee, which under Section 15 of the 15.3 of the Legal Practitioners Act that have calibrated what you are supposed to charge. And once you go against it, by Rule 11 of that order of 2023, it's a punishable, act. And so, while lawyers will, the junior lawyers will try to undercut the office, they should also know that that is a punishable under the Legal Practitioners this in 2023. And then we go to abuse of professional ethics. This is also another offspring of poverty coming from socio-economic uncertainty, because it's a erosion of the integrity of lawyers in the legal practice. First, we now go to the matter of dressing. Dressing, people will just take it for granted, but it's very, very important. A lawyer has to dress, and that is viewed as a prism of an accomplished man. He looks like an actor, and so he must be dressed always. And like Oputa put it, dress is an index of personality. But incidentally, you find out that many lawyers, particularly those you can find in the cognomen or nomenclature of we call it charge and bell, which I know nobody here is involved in, but at least has to be there for the record, that they dress shabbily, they don't dress well. And incidentally, litigants use physical appearance as a barometer to measure the success of a lawyer, the confidence they will repose in you. So good dress will make or mar a lawyer. But incidentally, many lawyers dress shabbily, and it is the detriment of the legal profession. Then again, because of poverty, you find that arising from socioeconomic uncertainty, you find that so many lawyers these days cannot afford to buy cars. It's not their fault. They cannot afford to buy cars. And because of that, they now indulge in a very despicable act. That act is, you see him wearing his collar and studs, and they just minus the wig and gown, which is the paraphernalia of the office, and you see him mounting a motorbike, which is, it's despicable. It's not something that's supposed to be seen at all. But it's a result of the poverty arising from socio-economic uncertainty. And we should know that that act of poor dressing and the rest of them, or dressing, with lawyers' regalia going about, offense rule 45 of the legal practitioners, of the code, rules of professional conduct. So both the poor dressing and then the mounting of Okada, though occasioned by socio-economic uncertainty, erode on the integrity of the legal practice, as clients disregard lawyers resident in this deplorable class. Then in the same vein, you see some lawyers, because of socio-economic uncertainty, are really enveloped in impoverishment due to, the situation of things. So a written of lawyers are, let me use the word of my Lord often, destitute of funds. They don't have funds to run legal offices and chambers. And to this end, they patronize computer, centers, public business centers to prepare very sensitive documents that are very, very sensitive. And as a matter of fact, you even find out that because of that, they even use the computer operators as their secretaries. They collect money for them. They call them on phone and tell them, Barry, that person has just paid 10,000 naira, which is infra-dig. It's not supposed to be done. This also, erodes the integrity of the legal practice. And it offends Rule 41 of the RPC. So that's not all. The harsh economic uncertainty push lawyers to engage in an untoward act of now they confiscate, divert, and then convert the lawyers, the client's fees. This is a requirement of Rule 23.2. They take the money without any remorse, and then that is a very unusual misconduct, which is punishable, but it erodes the integrity of the legal practice. And the University has just described and cataloged the dismal effects of paucity of integrity on legal practice in this elementary world. Please permit me to read it. If there's one thing lacking in large numbers at the bar these days, and which is desperately required for success, it is integrity. Honesty must be a watchword to succeed in the new century. It is an ingredient for success, much needed, but sadly in a very short supply. When clients and colleagues can take you for your word and have confidence and trust in you, the most significant and most sensitive briefs will come to you. Integrity is what it takes to keep clients for years. I think maybe the minister foresaw this because the man using Bill Clinton as an accompany to do this thing. That is sharp practice. And so the legal practice of lawyers who possesses and husbands integrity of the legal profession will dwarf that of an advocate whose dignity has vaporized. And then we also see another problem arising from poor economic situation, and that is infiltration of the legal practice. The corrosive effect of economic uncertainty, that is raw penury, breeds ingress and egress from the legal profession. In hunting for greener pastures, lawyers and the laity engage in the scapegoat racket of inciting people to romance with litigation. This is just for instigation. The reason is just instigation. It is practiced with the underhand understanding to share any profit germinating from the action with the litigant. The unholy act of practice wears the inglorious garb of champati. I think we saw that when we were in the university. Champati is a bargain wherefore a party in a suit is assisted by another person with a view to sharing the profits of the suit. This tricky legal practice has been seriously censored by jurists. And one of them is this. It says the direct opposite of honest advocacy, that is my Lord Sisinweze of the blessed memory. The direct opposite of honest practice is gulfy advocacy. Advocacy in this category are known more for their chicanery to appear before the court to plead for litigants or accused persons. In another facet, other professionals invade the territory of lawyers in commercial legal practice by signing legal documents. It constitutes a naked usurpation of the historic legal practice. It diverts the legal practitioners of the meager resources available to them after the toxic consequence of social economic uncertainty. Of course, gentlemen, I think we know this. There are fake lawyers around, many of them. I think it was last week, a judge in Anambra State sentenced one to prison for appearing before him. And you see other professionals now engage in commercial practice, properties, and the rest of them, taking away what the lawyers are supposed to do. These are just fallouts of socio-economic uncertainty. Then we also have another, well, after that, we try to do what we call comparative jurisprudence in relation to legal practice. Of course, in doing so, we just looked at the UK and the US. They fare better, the economies are fairly stable, and then insecurity thrives at its low level. Corruption is being wrestled down and tamed. Social amenities are in abundance and they're efficient. Standard and cost of living are affordable. There are hospitable environments for citizenry. In the premises, there is marginal economic uncertainty, which is the bane of developing countries. Indeed, in those countries, harnessing technology has climbed to its apogee. They have attained the next and highest level of legal practice. And that next level, which we are going to see, is globalized legal practice. The UK, US, and France are the generalissimos in this globalized legal practice. Lawyers are well remunerated in those places. The wages of lawyers are very high and impressive. For instance, one lawyer in the US posited, lawyers enjoy one of the highest national salary averages in the New York. New York is the legal epicenter of US with robust legal market that offers multitude of opportunities. London has been crowned with a global legal powerhouse known for its expertise in commercial and financial commercial law. In this wise, the minimal presence of socio-economic uncertainty in most of the developing countries, particularly US and UK, makes legal practice rewarding and lucrative among lawyers of all strata in the legal profession, unlike in our developing countries. And having done that, one has just gone to the recommendations. What are the way out of all this? How do we get out of this doldrum? And one of them is legal partnership. Of course, we know that partnership, which comes in various forms, is a voluntary association of two or more persons who jointly own and carry on business for profit. And so when a legal partnership is born, when two or more lawyers just agree and jointly carry on business for profit, and then to share the profit and losses, then we have legal partnership. Two or more law firms can come into legal partnership. Legal partnership entails building confidence and trust in one another. It promotes cross-fertilization of legal ideas for a progressive legal practice. In developed countries, you can find them, UK, US, for example, we have quite a good number of them. And then in Nigeria, there are a few legal partnerships that are thriving, but not as much as we had expected. And then the merits of legal partnership have been chronicled by legal colossus, and I quote him: partnership between lawyers and among law firms in Nigeria should be encouraged. Apart from economies of scale, partnerships encourage capacity building and specialization as lawyers in given fields understand the intricacies of such areas and are able to give first-class advice in their areas of specialization. It will also increase earnings for the firm and lawyer alike as more income is generated. Economic prosperity is only possible where one is able to spread its tentacles to other emerging areas of practice and reap the benefits of doing so. That is the advantage, or these are the advantages of legal partnership, and I encourage lawyers to get out, to navigate out of this doldrum, to go into partnership. And then we have also another way out, and that is specialization, in-depth study of a particular area. This will invest the lawyers with rich knowledge in recondite areas of law for a total advancement of legal practice. Again, it's advisable for lawyers to acquire extra additional certificate qualification in cognate field to one's area of specialization. It's also important for lawyers of this 21st century, which many of us belong to expand the horizon of legal practice and venture into burden areas in the legal market, such as, just like the minister indicated, atomic energy, aviation, communication, admiralty, capital market, oil and gas, insolvency, international economic transaction, intellectual property, data law, cyber law, taxation. These inter alia are the yet to be harvested areas in the emerging legal market with their attendant generation of elephantine income for legal practitioners. And the advance lawyers to key into it. And then we also have another good area that can help the lawyers out, and that is cross-border legal practice. Cross-border legal practice. Cross-border legal practice, which owns some other sub-requests, can also be called multi-jurisdictional legal practice, globalized legal practice, or deterritorialization of legal practice, connotes the act of rendering of legal services by legal professionals beyond the boundaries of the legal professional's home country. For proper actualization, it requires knowledge of legal systems, laws, and policies of different countries. In practice, it obeys around the establishment of a branch office of a law firm in a foreign country whilst maintaining its headquarters in a local country, thereby offering legal services to clients domiciled in distinct national jurisdiction by maintaining physical offices in those various jurisdictions. The UK, USA, and France are leaders in globalized legal practice. On the other hand, of a contra, no foreign legal firm has been established in Nigeria. Admittedly, there are attorney hiccups on the route of the slippery cross-border legal practice. Nevertheless, it possesses lots of advantages and will assist Nigerian lawyers to navigate out of the shackles of the socio-economic doldrums in legal practice. So it's really new, or rather new in Africa, but in England, on US, you find cross-border practice. They have their every, but here, because of certain situations, or because of the economic situations, lawyers do not engage in cross practice. And it's been recommended that lawyers key into that. That is one of the ways to get out of this socio-economic uncertainty. And I also see something like the next recommendation is sanitization of legal profession. Legal practitioners who, out of unjustified loyalty to the socio-economic uncertainty, infringe on the prohibited provisions of the RPC and LPA should be made to face the wrath of the law. This is because their unprofessional, infamous conduct, which cannot be rationalized, however, bears an indelible stigma on the nobility of the legal profession. The Legal Practitioners Disciplinary Committee, LPDC, which by the PA, is positioned on the proper activation of the appropriate provisions of the RPC, ostracize such delinquent lawyers from the double profession in deserving cases. And then at once, other professionals or quacks who trespass on legal practice should be prosecuted in due fidelity to the law and appropriate punishment meted out to them. This will serve as deterrence to others as it will abort in the embrace the brewing and fertilization of such odious ideas in others, which carries the potential to tarnish the soaring image of the legal profession in Nigeria and depressing the lawyers of their revenue. This will help in a great measure to restore the glamour and prestige of the legal profession. Of course, we should know that because those who are the fake lawyers there and then those who do other things that are not there, they should be weeded out. They should be sent out of the legal profession to make room for lawyers who are serious to earn their living, notwithstanding the socio-economic situation. Then there is also another way out. And this time we talk of employment of alternative dispute resolution. It is not economical with the truth that Nigerians, of course that is the position taken by some people, Nigerians are the most litigious people on earth, especially the political class. Our courts are inundated with battle of causes and matters of different magnitude, coloration, and the complexities. The strong desire of the teeming members of the public, the ultimate consumers of justice, man's greatest interest on earth, is to obtain it and at an affordable cost. It is difficult, nay impossible, for the courts to meet the widespread and tall expectations of the public. It is this inability that furthered the alternative dispute resolution regime. And of course, we say what it means here, and it refers into four. You have the negotiation, mediation, arbitration, and conciliation. Its importance cannot be overemphasized. Settlement of cases amenable to ADR will shrink considerably the tons of cases on the docket of the courts. It is hostile to undue delay and technicality, which are worshipped in the adjudication of disputations. It is cost-effective, it is pocket-friendly. It produces justice and satisfaction, thereby expelling open animosity and rumor among disputants which are associated with adjudicatory practice. It expands the income of the advocates. Industrialized nations have embraced it fully. Admirably, it has been assimilated in our corpus juris because most rules, of course, in Nigeria provide for it with the appertinent structure for its application. And for transactional lawyers, corporate lawyers, of course, there is now an online dispute resolution, ODR, complements the ADR. Flowing from the enormous advantages displayed above, it is advisable that legal practitioners deploy the ADR fully in order to avert the dire consequences associated with socio-economic uncertainty. This needs no explanation because it's there that lawyer will earn his money without any qualms, without any problems, without traveling out. You are paid very well. The litigants are satisfied. You retain your clientele base. But unlike litigation that you have to suffer for several years, junketing from one place to another and the rest of them. So it is good that lawyers employ ADR. And then we have continuing legal education. According to the legal guru, that's Lord Denning, he said, I just remind ourselves, God forbid that a lawyer knows all, but a good lawyer is one who knows where to find the law, unquote. And then this familiar aphorism, because very familiar, we knew it from the university, foreshadows and underscores the imperativeness of continuing legal education. And by way of doxology, Rule 11 of the RPC caters for this. Continuing legal education will aid lawyers to acquire and lubricate the requisite knowledge of law and ethics of the legal profession. Law is not static, it is dynamic, and should have the potency in solving new problems sprouting from the changing conditions of life. Lack of continuing education will tempt a lawyer with intellectual decay, which will rob him of the needed capacity to enhance the frontiers of legal practice. And of course, the recommendations are endless, but I will stop at this place. And I will go to the epilogue. That this superficial juridical survey, occasioned by paucity of time and spectral content, exposes the dwindling fortune of legal practice due to the daunting socio-economic uncertainty in this country. The dissection has demonstrated that it requires the collective efforts of the government and stakeholders of the legal profession to rescue the legal practice from the claws of socio-economic uncertainty. Short of that, the struggle by the Nigerian legal profession to maintain its prime position, a pride of place among the community of legal professions in the world, in presente and in futuro, will continue to echo and roam around the landscape of a pipe dream. Ladies and gentlemen, I thank you for your elastic patience. Thank you so much.
Thank you very much, my Lord. Our keynote speaker has done justice to the theme for this Law Week, the NBA Yenagoa Law Week. One thing I have to say is my Lord did not just identify the causes of socio-economic uncertainties. Please be seated. But he also preferred solution to the problems of socio-economic uncertainties. And on that note, shall we please put our hands together for him again? Thank you so much, my Lord. Shortly, we'll be proceeding on a tea break, and I crave your indulgence that the tea break will just be 15 minutes so we can come back for the panel session. Remember, we still have the technical session, which is the panel session. Before we proceed, I would like to recognize the member representing Ekanamo Constituency 2 and Chairman House Committee on Environment, Honorable Living E. Meeting. Please, a round of applause for him. And I have the pleasure of also recognizing here with us a Justice of the Federal High Court in Yenagoa, Honorable Justice Isa H. Dashen. Please, a round of applause for my Lord. And so, ladies and gentlemen, this is how the break will go. Those front row will proceed first, followed by the judges who are here, and then we'll be told how to move row by row. Please, on no occasion should you stand when it hasn't gotten to your time. Let's have all those on the front row proceed for the tea break now. They will serve them here. Okay, my lords, you can sit down. I've been told they will serve you your tea here. Mrs. Boma, can the judges come over there? They should also sit down. All right. Okay, my lord, the Chief Judge of Bayelsa State says she would prefer if everyone proceeds there. So let's go back to default setting. Those on the front row, please move now for tea break, and then followed by the judges who are here. And while we're going, I would like to recognize a member of the bar who is here with us, a doctor of law, Dr. Dennis Otiotio, chairman of APC in Bayelsa State. You're welcome, sir. My lords, distinguished ladies and gentlemen, a good number of us have had our tea break, so while we have just a few of us still at the tea stand, we would like to proceed with the panel sessions. I'd like to invite our panelists. In no particular order, I would like to start with Honorable Justice Peter O. Afeng, JCA. Please, a round of applause for my lord as he comes to take his seat. And please, the organizers, I'll need one more seat here. I need one more seat on stage. I need one more seat up here, please. Next to come up on stage, Honorable Justice Temepri Songi. Please, a round of applause if your hands are not busy. Also to join them is Honorable Justice Daketima Gabriel Q, PhD.